Good morning, Rie. How are you doing?
I am really anxious because this is the first time we are doing this. And I'm not sure if we are live on LinkedIn yet. So excited.
I'm
How
very
about you?
excited too. I'm super excited. This is terrifying. This is an entirely new platform.
Yeah,
And yeah, and we don't do videos usually.
it's okay. We are live. I just got it confirmed.
That's
So
amazing.
cool. If anybody is watching live, can you please add a comment so that we can see if there are actually people here? Yeah, morning, guys. You are live. And I see in data protection spirit a lot of anonymized LinkedIn user comments.
I think it's just in the spirit of the GDPR, as you say. And I think that this is, do we need to do a privacy notice real quick if we're recording this?
Yeah, you go ahead. And I
Uh,
love the fact that you said privacy notice, and I will forever hold you to that.
Privacy notice? No, privacy policy is what I meant. I meant
I
to say
won!
privacy policy.
Woo!
No.
Morning, Mario and Christina.
Okay, privacy. I see ourselves on the screen. Sorry, I was just checking. I just wanted to have comments straight there. So, do we do Article 13? I have my copy of the GDPR, as I'm sure you do as well. Is it 13 or is it 14? We can do it super quick.
Well, we're
Let
deleting 14, aren't we? So,
Yeah,
but
we
let's
are,
do
and
13.
13. Yeah, let's
This,
do
folks,
13.
is actually from 2017, and it's really, as you can see, yeah, falling apart.
It is. It is. Information to be provided to you guys following on us today, where personal data relating to a data subject are collected from the data subject.
No, thank you. Okay, we are done. Miloš, you are out of
Okay.
here.
Yes, but the idea today, and thanks everyone for joining, is to go through the entirety of the GDPR. Super ambitious, but you guys know that we love speaking real quick. Why are we doing this? Because we feel that something is getting lost in the discussions about the GDPR. We feel that the balance between fundamental rights, now I sound like the Court of Justice, basically, I feel that the GDPR is not working as it is. It's not working in terms of us as data subjects. It's not working in terms of what businesses are faced with, and it's not working for the authorities. And is there anything better one can really do than go through it article by article and tear it down? Rie?
Yes, sorry, I was gonna send a comment saying good morning to everybody because everybody is saying good morning in the comments, which is super nice. So please keep them coming. And as you know, we love emojis. So add your country emoji to the comments so we can see where people are dialing in from. And yes, Miloš, I think you are spot on. This is the best topic for a grumpy discussion between the two of us, I think. Two very opinionated people, right?
Two very opinionated people. I just, as a disclaimer, wanted to say, like, we're not doing this because we're grumpy and arrogant and want to delete the entirety of data protection legislation. We do feel it's important, but we do feel it can be done better in a more understandable way, and that lots of headaches can be avoided by what we're just about to do. So why don't we just dive straight in? Do we start with Article 1?
Let's do that. I just want to mention that I'm not a lawyer, so just keep that in mind. So I'm gonna say lots of silly things about the what do you call it in English? Juridisk metode.
Legal methodology, I suppose.
Yeah. So, but I think this is actually a benefit, and we'll come back to that.
Yes, I agree. Okay, subject matter and objectives. Article 1, you want to share?
Yes, we are live. Can you see our GDPR text, people?
I can. Can you zoom in a bit?
I can try.
Awesome. Maybe, yeah.
There, and let's remove the grumpy banner. So I just show you the URL if you want to go check out the Grumpy podcast, but it's on every platform as well. So
you know us by now. Come on.
Yeah, you do.
You do. Regulation of the European Parliament and Council on the protection of natural persons with regard to the processing of personal data and on the free movement of such data and repealing directive. Okay, name? Do we change? It's fine.
We could just shorten it, right?
Privacy Act.
Oh, no, you didn't. It's not going to be called the Privacy Act.
Watch me. Okay, fine. Subject matter and
let's do
objectives.
this.
Yes, the regulation lays down rules relating to protection of natural persons with regard to processing of their data, protects fundamental rights and freedom of natural persons, in particular their right to protection of personal data. Redundant. 1 and 2 say the same thing, as far as I can see.
Yeah, so combine.
Yep.
Yeah. And I think let's just, don't worry, people, we will not read out every article.
Nope.
So Article 1, I think that's fine to keep. I would say
keep.
Yes.
Yep. The third paragraph is redundant. Free movement shall not be. Okay, fine. Leave.
Yeah.
Keep. Do we put a smiley face on it?
Yeah.
Yep. Smiley. And we're going to share the doc. You can't see right now, but on the side, we will have smileys and we will have grumpies and everything. Material scope, what does it regulate? I don't think that there is much to be said here. It's good that they're separating it from crime prevention things. Sorry, that's a tough word to say. I think this is mostly okay. I don't see much problematic. I do. I'm lying. Applies to processing of personal data fully automated or non-automated. You remember the whole is something a filing system. I would get rid of it, I think. What does not end up being automated?
It is so funny because one of the examples I always get is, so what do we do with the business cards? Everybody wonders about that, right? And then I say, well, okay, if you just have them laying around where you're sitting at your office, the GDPR doesn't apply. But if you put it into one of those, what do you call it, those spinning cards type of things?
We're too old. I know what you mean.
Then
Rolodex.
it is a part of a filing system. I don't have too many issues with Article 2, but I would actually add something.
Yes.
So first of all, I think I would move Article 23 here. And just to have that said, people, Miloš and I, we haven't discussed this in advance. So we don't know what each other's stances are on the different articles. So that is exciting. We haven't super prepped for this. So please keep that in mind. But the one thing that I think maybe will be a bit of a bombshell is that I would add an exemption for B2B marketing.
Oh, that is good. And I agree, business email addresses. Why would we keep this? Again, if the goal is protection of personal data of natural persons, and we do have this throughout EU legislation, so it applies to things which are outside of trade or profession. And I think that definition as well is problematic with influencers and stuff. But yes, I would limit it for sure for business context. For filing system, I've already made a dad joke on LinkedIn that your thoughts can be file system because you can access them individually. So get rid of that.
And people, if you want to add which articles you want to delete, please add it to the comments and we'll have a stop on the way to see what you guys are saying.
Which emoji? Yeah, like a meh one? Smiley?
I think it's mostly fine.
Okay, let's leave the upside down smiley.
Yeah.
We're mostly fine. Awesome.
And now Article 3. Somebody told me they wanted to delete that one. What do you think?
Absolutely. Get rid of it in a blink of an eye. Once
the
again,
entire thing?
The entire thing. The entire thing. Okay. Applies to processing outside of Union. Applies to controllers and processors outside of the Union. We will touch upon this when we come back to Chapter 5, but the problem with this is enforceability. Once again, to reference my own infinite wisdom, I made that joke on LinkedIn that basically in the entirety of known universe, if aliens were to find out that Earth exists, they would get a letter from the EDPB. Makes no sense. It's not enforceable. Administrative decisions in general, you would need a court decision, and even those would be tough to enforce abroad. Why? What is the benefit?
Mario agrees with us that we should delete Article 3, but I hadn't deleted the entire thing, but I had deleted, let's see, this.
Okay. Can you do the smiley face there? Or like the keep face? I can do it.
Or like this.
Yeah. The last offering of goods and services. I don't know, because otherwise, how do you do the criteria? Never mind. Let's
No,
not.
I'm just thinking if you process personal data of people in the EEA.
Yep.
That's it.
Oh, wow. You would even extend it in that case, because it only applies if you offer goods and services or you target them.
I don't see how this just complicates it. So if we were to keep Article 3, I would delete that part, but I don't know.
But then
Let's
it applies
come back to it in chapter 5.
Well, yes. Article 4. I've been waiting for this one.
Okay, if you're excited, go ahead.
I'm super excited. Personal data, meaningless, stupid, all-encompassing, too broad.
Yeah, way too broad.
Way too broad.
It's basically everybody and everything.
Everybody and everything and all at once. I was joking a couple of days ago, if I get like 2 eggs and they're stamped with a number of where they were produced, 1 egg could be personal data if you can tie it back to the farmer who produced it based on the number.
Yeah, exactly. And it's a real case scenario, right? So it makes no sense. It is absolutely way too broad. So how would you limit it then?
What is personal data? I would strike out identifiable and limit it to only the situations where the controller can identify someone and lower the threshold. Like, yeah, I think. And maybe not even all kinds of data, though. I would have to
like
think.
what?
What would I leave out? I haven't really thought about this too much.
Okay, but since we have 99 articles, let's move on, and then we can come back to whatever things we are pondering.
Pseudonymization stupid? What does it bring? What does it bring to the table? Like, yes, this is a security measure. Okay, fine, consider it under 5 or 32.
Yes, that was actually gonna be, because what I'm pondering is, first I thought, okay, let's delete the whole thing. And then combine it into the articles, the respective articles. Yep. So like move that part, the pseudonymization, into the security and data protection part. And the second thing that I had to add there was that I find the definitions are really strange. Like, why have they included some of them and not others? When necessity and proportionality, high risk, data subject, like, why haven't they added those definitions that people are scratching their head over? So I would, if we had to keep it, I would add to it and then remove everything that pertains to DPA-specific stuff, like these ones.
Yeah, because that has its own place. I know this is like the typical layout of EU legislation, but it freaking sucks. I know lots of discussions happened around recipient. To this day, I have no idea of the significance and the actual legal significance and consequences of that.
Yeah.
It's spread throughout. Third-party personal data breach. How do you feel about breaches? Breach of security leading to, it's under 12. Unlawful destruction, loss, alteration. To me, it's kind of too broad. I
think the definition is fine. I would move it into the security section, though.
Yeah. I think that's mostly that. Representative, this is, we'll come back to representative.
We'll come back to lots of these.
And controllers and processors, I want us to take down when we talk about obligations of controllers and processors. Principles.
I am sure most people who are attending now know our stance on this. And I would love to know, people, is it a yay or a nay to keep Article 5? And I'm looking at the comments now. I'm also saying, remove online identifier, please.
Yes.
Yeah. We need to delete the entire e-privacy directive, but that's another LinkedIn Live.
That is another. Is it though? It takes 30 seconds. Delete.
Yeah,
the damn
delete.
thing.
Yeah.
Yep. Delete period. Principles, amazing. Whenever I teach the GDPR, if I have like 30 minutes, I just cover the principles.
Yeah.
That being said, I do not necessarily understand all of them. Purpose limitation shall not be reused for non-compatible purposes. And then there's the whole thing of data needs to be collected again. But at the same time, if you repurpose, that just means that you cannot, that you need a new legal basis. So why would I need to collect it again? What the hell does that mean if I have a legal basis?
You are on B now, right?
Yes.
Yeah, which relates to 6.4.
Exactly.
Yeah. And I struggle with that as well, because it's, yes, you might be able to repurpose, but you need to inform people at the same time.
Yeah.
So if you are obligated to inform them, why just not ask for consent then?
Right. But also, how do you inform? We can circle back to that in 13, 14. But let's say that you're repurposing for legitimate interest. I get your whatever picture. No, I get your name and address, and I want to do something compatible with it. Then I don't need a new legal basis. Right. As simple as that. I think that is clear. But if I do repurpose for a non-compatible purpose and I need to inform you, can't you just do that through privacy policy? No, because then if you can't use legitimate interest because of the reasonable expectations of the data subject, right?
Yeah, and they need to actually get the information. It's not necessary to just have it in the privacy notice. They have to actually receive it.
And we did 40 minutes on not really understanding what the purpose is.
Yeah.
What's the purpose of life? 42.
Yeah, that's also another podcast.
Yep.
But I have one question for you, because I have been really pondering one thing about Article 5. So overall, I'm with you on the, like, I print this out whenever I go out to clients. I put it on their wall. It's there years after I come back. And I really love how it sort of just summarizes the entire GDPR. So I absolutely love Article 5 for that. However, when I thought about this for the purpose of today, I might delete 5.2.
5.2. Accountability. Do they need to demonstrate compliance? Yeah. You know what? You have fairness and transparency. Depends on how. I think this is just about burden of proof. I would actually keep it that at all the times you are the one who has to keep the documentation.
Exactly why I'm considering deleting it, because I think the documentation requirements with the GDPR has just grown to impossible heights. Like for 99% of businesses in the EEA are small and medium-sized businesses. Most, by far, like 80%, are tiny businesses. And the documentation requirements with the GDPR are absolutely blown out of proportion, and much because of 5.2, I think. You should be able to demonstrate compliance with. And I just think that it sets an unrealistic threshold. And this was actually a new thought, completely new thought to me. So I'm really curious to hear what other folks also think about this. Should we keep or delete 5.2?
Where we disagree. Miloš wants to keep it. But look, what you can do is have an exception for SMEs and just limit, they shall only document Article 5 or blah, blah, blah.
Yeah, but it's not, that's the problem also, because how do you document Article 5? Like all of the documentation requirements in the GDPR are so absolutely incomprehensible. It's, you need to do the privacy notice, but like the legitimate interest assessment, don't even get me started on transfer impact assessments. Like all of the documentation requirements, this is a disease throughout our entire society. Like just look at general practitioners, and they can't even cure patients anymore because they're tied up in bureaucracy. So I know this is a much bigger discussion, but I think that it just shows so well in the GDPR as well.
Yep, it does. But I think that comes from the substance of the GDPR, right? I'm fine with the form, document compliance, but what is compliance? But we skipped over, I just dove into purpose because I think everything else kind of relates to the purpose. I want to say something about fairness, transparency, lawfulness. I can.
Yeah, go ahead.
Bloody fairness. Delete the fairness because it leads to unpredictable enforcement. If it's legal, it is fair.
Yeah, I think you're spot on there. I hadn't thought about that. I had added fair to the definitions that we need to define what it is. But I think your suggestion is better because we saw that so clearly in the DPC decisions. All the arguments among the DPAs that what is fair and what's unfair. And I absolutely agree. If it's legal, it must be fair.
Yeah, it's capricious, it's undemocratic. Okay. Explicit legitimate purposes, fine. Data minimization. We've also touched upon this in a Grumpy GDPR episode. Depends on how you interpret necessity. If you do the strict necessity test, we talked about that.
And look here, people. How many in the comments can see the word strict before necessary here? It doesn't exist there. I'm just saying. I'm not going to do another rant on that, but it's this is also a word that needs to be defined, that should have been defined in Article 4.
Well, I think you could take it from general principles of EU law and from some judgments, but I think that there is not enough there still to assess
I would delete this.
Yeah.
Isn't it enough to say that it's adequate and relevant to the purposes?
You can, yeah. Oh God, accuracy, out. Meaningless.
No, I would keep it.
Why?
Because then you don't need a right in chapter 3.
But I mean, come on, like.
So I would rather keep that, and then I would delete the right in chapter 3.
Having regard to the purpose is the key here. I think that
this is a given.
For most purposes, this is just going to be silly, unreasonable to apply. So I do like the reasonableness check.
Yeah, maybe.
Okay, I'm going to put smiley on reasonableness check. Why maybe?
Why don't you go ahead to the next one while I do one small thing?
So delete whenever you no longer need it. To me, that's kind of redundant because it's part of purpose limitation and data minimization. So if you already have the purpose limitation principle, which says you have to have a purpose, then there is no need for storage limitation. Because if you don't have
that is actually a good point. Yeah, I think I agree with that.
And honestly, come to think of it, the same with data minimization, you can build it into a single principle as well. If I don't have a purpose for this data, because it's extra, because it's not necessary, right? Maybe that's how they complement each other. Just bundle minimization with purpose limitation. It's too much to think about the two.
Yeah.
Yep.
Yeah, so keep for sure, but simplify.
Yes. 6.
Oh, this is a good one, right?
Oh, no.
I have let me please start with one big one. Let us please just move consent to the end.
Yeah. Yes.
So not deleted, but let's move it because it's just, why did they put it on top? Because everybody thinks now that consent, still in 2024, consent is what you should go for. And unfortunately, as we've seen in recent Court of Justice rulings like the KNLTB Tennis Association one, that in paragraphs 51 to 53, I think, there's this nudge for consent.
Oh, absolutely. So it seems to me the DPB and the Court of Justice look, contractual necessity and legitimate interest are rendered nearly useless by now, because you have the ruling saying it has to be impossible to fulfill the contract, meaning you can always fulfill it in another way, right? And legitimate interest, as you say, the ruling says, yes, but you could have asked them before you share the data, which is going to affect your legitimate interest analysis. So they've taken out those two. So what's left is consent and law. Oh, and even for laws, remember in Norway, they said, yeah, they do have this bylaw, but it could have been formulated otherwise. So
Yeah.
Consent or bust.
I have to make a comment because somebody in the comments are pitching their services and their book. And I find that really distasteful. And this is not the place and not the audience probably to be pitching your own services. No. So can you please stop doing that? Thank you.
I agree. I mean, hire me. I'm joking.
It's just really, yeah.
You would
okay,
never.
I'm not going to be super grumpy on that, although I am super grumpy at that because it's just so distasteful. Let it put it diplomatically.
Yes.
Okay, what's next?
Basis of process. I do not understand. Let me see. 3 and 4. Purpose of processing shall be determined in that legal basis. Okay, fine. And 4 is compatible use.
Yeah.
This is too complicated to read, way too complicated, especially for mornings. I'm extra grumpy. We always record in the afternoon. This should be moved at the very least, together with the purpose limitation principle.
Yeah, probably. That is actually a good idea. And also, I wanted to ask you, since I mentioned the B2B marketing exemption, so that could be solved in different ways. So it could be in the exemption part or under scope, or it could be its own legal basis. Or we could have a marketing regulation that is lex specialis over GDPR. What do you think?
Honestly, I would just put it the same place as you do household exemption.
Yeah.
Just say it does not apply, period. And then if you want to regulate it, you have unfair commercial terms directive, you have platform to business. Like, they were not bored. They kept busy. So yep, I agree with you. Are we at 7?
We are at 7.
Delete.
Oh, let me
defined as freely given. This is fluff.
Also, on the definition, I had deleted a few words from the definition to not make it so cumbersome to actually achieve in practice, because most of us who have worked hands-on with the GDPR knows what a nightmare this can be, and it doesn't actually limit anybody's fundamental rights and freedoms, in my view.
Then we have kids, children, Article 8. Honestly, I would make a separate regulation there, because now the thing is, you have rules on children in the DSA, you have special rules on children sprinkled all throughout, and I think it would be far, far easier. We have a problem with identification. How do I know that somebody is a child? I keep laughing at this and bringing it up when the DPB said, a good controller knows their audience. Do you know your audience, Rie? You're not a bad controller. Bad controller. Okay.
So delete.
Yep.
Yeah.
And now my favorite.
And only people, because we want it to be a special regulation, because the kids deserve that, right?
Yes.
Okay. Number 9. Please, people, tell us in the comments, keep or delete. And I will have my little sticker ready. And I really hope that you appreciate my little emoji flags that I made myself yesterday evening. And do you have yours ready?
Yes.
Miloš? 1, 2, 3.
It even doesn't want to focus on it.
Out of here. It is so deleted.
It is so deleted.
The
Number
entire
1.
thing.
How the hell did they pick the categories? My philosophical beliefs. I love Immanuel Kant.
How I can't wait for the Court of Justice case to define that.
Yeah. And now everything is Article 9, right? After that
Everything
case.
is Article 9 after last year's, or was it 2
Yeah.
years ago? 2 years ago.
Jesus, time flies when you're living with horrible articles. Um,
But I want to make just a comment on Article 9. And the example that I always give is you have a secret street address that, if known to certain persons, pose a real life and death situation for some people. And that is not special category.
Yeah.
Whereas your peanut allergy, that is special category. It doesn't make any sense whatsoever. It is all about the context. Like whenever I do speaking gigs or teaching, I have that on a separate slide, like context. It's all about the context. And then the second really key thing is the risk-based approach. So if you combine those, I would say that you would get significantly better protection and privacy for people, because you look at the context of the processing, you look at the people. They live on a secret street address, then please don't broadcast it in the new school app that happened in Norway a few years ago. So I'd say it comes down to context and risk-based.
But
what do you think?
Which makes it extra unnecessary, because when you think about it, you would have to do a DPA, right? You would have to secure proper legal basis for it. So of course the risk there is going to be high. So what does it bring to the table?
Yeah.
So the threshold for processing it is high anyways.
And strange for us in Norway, the trade unionship, which it doesn't have any significance in Norway, while you go other places in Europe, it definitely has, but I think it's too particular, it's too strange to have it in there. So delete, and I can see in the comments, amen, delete, delete, delete.
I mean, when it comes to what they picked, they probably had like a hat with like a bunch of different types of data. We're just, this is sensitive. Okay, 10. I would keep a special regulation, put it, no need to have it in here. We already have stuff on law enforcement, other places. Yep.
Out.
Oh God, I don't understand 11. Can you please try to explain this to me?
I looked at this yesterday as well, and somebody told me they would delete Article 11, and I can't make sense of it. It is for really strange cases. I found one in the GDPR hub about somebody sent very sensitive nude pictures of somebody to a ministry in a country, and she claimed it was of her, and then they had to identify her, and they wouldn't, and then the DPA found that, okay, you don't have to try to identify this naked woman just for the sake of it. So if that is the only case that we can come up with, I'd say for sure, just delete it.
Yep. But also, if you, it's personal data, of course, because you don't have the means of identifying them. But that does also kind of bring me to the point back to the assessments under. Never mind. I'll circle back to that later.
Yeah, we are 30 minutes out, so we should have been covered 3 soon. How many of the GDPR pages have we deleted so far? Mario, we have deleted quite a bit, so we will zoom out and look at it in its wonderful entirety in a while.
Right. Do you want to lead on?
Yeah, Article 12. I would keep largely. I think that this is one of the best things, actually. Yes. Plain language, gjendansk, klarspråk. This is so immensely important. If you can just explain it easily and well enough, then yes, that is what we want. So I'd say that this is one of the key sentences, actually.
Yeah. But I mean, it is also part of the principle, but fine. Okay.
Yeah, I think it needs saying again.
Okay. Yep. The information.
And then redundant. Like, of course, you shall facilitate for the right. Any other comments on 12? Oh, yes. This one, for sure. What are your thoughts there?
Keep.
Yes. And
Keep,
I
definitely.
would lower the threshold. Because like in, was it Hungary? They had to receive 80, the DPA had to receive 80 requests before they found it excessive. And,
Wow.
that's another scenario. But I think even as we've seen in Norway too, that the threshold is way too high. So we need to lower the threshold for when is a request unfounded or excessive. Because you have we'll come back to that on 15, my favorite term from Abel, revenge DSARs.
We can. That is a topic entirely, I feel. But let me think. There is also that possibility, of course, to charge a fee, which I think you could quickly end up running counter to the principles. One thing is if they ask for too much data, you can ask them to specify which data. I don't really understand or know how this is being done in practice. I've never.
Yeah, but if you remember the guidelines from the EDPB, that is such almost an impossibility. Like they expect you to reply in full regardless.
Yeah.
And that's another issue. Not only the legal text, but the overinterpretation by both the EDPB and the Court of Justice in certain cases.
Yeah. And I would also, when it comes to deadlines, if they're in this article, I can't remember, 30 days plus 30,
Yeah.
or if it's later, remove the number of days just without unreasonable delays. If I ask you for every single thing, make it discretionary, case-by-case assessment.
Yeah, I was wondering about that, whether or not to delete the 1 month. But the problem is that it will have to be defined through the courts anyway, because somebody is going to question what is reasonable or not.
Yeah. But 30 days can be too strict. Just set storage limitation, just set everything to be deleted after 29.
Sorry?
Storage limitation, just set all the data to be deleted after 29 days. Problem fixed. Nothing to give access to. I'm joking.
Okay, sorry.
13.
13, yes.
Burn it to the ground.
Really?
Oh, yeah.
Seriously? How would people know?
Come on.
You must inform to some degree what people do with your data.
To some degree, absolutely. But look at the bloody list of what you need to inform about.
Yeah, but if you say burn it to the ground, I read that as delete the whole thing.
As it currently is. But you have the principle of transparency and information to be provided to data subject. Okay, fine, you can specify, but this list is too long, and I would just put it under the general principle of transparency. Also, if we do oral processing of personal data, I think it's yes. So I would most certainly delete parts of it.
I would delete parts of it, and I would combine it because it makes absolutely no sense with the 1 and 2. That is just super confusing, and even the EDPB seems to have scratched their head over that. So I would combine it, make it significantly shorter and easier to implement. And then I would probably change 13 into something like you need a general privacy notice, and then just-in-time notices for whenever you collect data. So you need to inform for a newsletter, for example, just give the information of that processing at that time with the link to the privacy notice. That is short and sweet, because what they say in 12 directly contradicts the enormous list in 13 and 14. Doesn't make sense. You can't deliver clear information if your privacy notice is 27 pages long, which it has to be to cover all of those points.
But that is exactly one of the things we set out to do today, is not just burden for business, but also how this affects data subjects. This renders data protection meaningless. Even for crying out loud, even the EDPB wrote nobody reads privacy policies.
Yeah, they did actually say that, people.
And
True
that
story.
is just mind-blowing. Yeah.
Yeah.
14 combined with 13 delete.
Yes, and just move the part because there are two things about 14 that's not in 13, and that's the categories of data. And also, I would amend it by saying that whatever the data subjects obviously knows from before, you shouldn't have to say again. I subscribe to the newsletter. Of course, you know that you gave me your email address, and the same with the source as well.
Yeah. Right of access, that you can ask for information redundant because you have, like, that part, that you can get information about processing. You should already have the information if you comply with former 13, 14, right? So just,
because this is, go ahead.
No, that's it.
Yeah, because that is the issue. There's such an overlap between 12, 13, 14, 15, and 30.
Yeah.
So why do we need to elaborate on all of these things in various ways? So just combine everything as much as possible into one provision.
Yeah.
And then I would heavily limit the right of access compared to how the EDPB has described it in their latest guidelines. It is way too broad. It is absolutely impossible to deal with these revenge DSARs. And as Abel says here, it takes time and effort from legit requests.
Yeah.
As TIAs take time and effort away from what really matters in privacy and data protection.
And let's not forget that each time there is an access request, you basically have to do more or less legitimate interest assessment, because you have to think, how is this going to affect third parties? How is this going to affect someone's freedom of speech?
Yeah.
So it is demanding. I see the logic behind that, so I wouldn't remove it, but too broad.
Yeah.
Get a copy of data, but I think that information in any case is getting tossed out. Rectification, please delete immediately.
Yeah.
Yeah.
That is such a given. It is. I don't understand why it's there at all.
No. And now, can I blow your mind?
Yes.
Delete the right to deletion. No. Hear me out.
What?
Hear me out. If you look into when you can get your personal data deleted, if it's no longer necessary, okay, then you're in breach of purpose limitation, right? They withdraw consent and there is no other legal basis. Okay, then you have no legal basis. They object to processing, you have no other legitimate interest. Yeah, then you have no legal basis. They have been unlawfully processed. Okay, that's illegally processed.
Obvious.
Yeah, they have to be erased to comply with the law. Okay, and KIT stuff, Information Society Service. So all of these cases are basically when personal data is already being unlawfully processed. So somebody's beating me up and I say, oh, can you please stop beating me up?
But how about legitimate interest?
But look, the legitimate interest thing is they object and you have no overriding legitimate interest, meaning that you do not have that as a legal basis. So in that case, you have no legal basis. So they've already gone through right to object.
And if it goes in your favor, it is lawful. Yeah. Hence, they can't get it deleted.
Yes, this is a very random take on it, but I don't see that this brings much at all.
That is a completely new perspective. I have to think about that.
Yeah, we haven't talked.
It makes sense what you say, right?
Yeah, I think, look, maybe there is something about repurposing or stuff there, but to me, it just seems to be clear cut of you're doing something illegal, period. And then, I have no words.
I would love to hear examples where, so if anybody knows concrete examples where we would obviously need the right to erasure that Miloš didn't cover here, then please add it to the comments. I will go and read all of the comments after. So I would die to know when this wouldn't actually be covered then.
And my God, the two, where the controller has made the personal data public and asked to erase, they shall make it possible for other controllers to find out if it's reasonable. Like the right to be forgotten basically is in there. I process your data, you ask for deletion. I need to let everybody I can possibly let know that you, Ria, has asked me to delete this. It's nonsense. It's like when...
But maybe it's like, because I'm thinking of cases where I myself asked for erasure, and that was typically data brokers and the likes. And I think maybe we need something in hand, so to speak, to leverage against those kinds of processing activities. Because how would you, like, otherwise I would have to go to them and quote legal basis and such. So for me as a data subject, I think that I want to keep the right because it is one of my most important tools to leverage.
Yeah, but this is about where the controller has made it public.
No, I'm just thinking general for the article.
Yeah, sure. I still think you can couple it with accountability and legal basis, and I don't see much that it brings. I could be very, 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 very wrong when I say you need to delete the right to deletion, because the processing is then unlawful anyways.
I would keep it.
Hence, we disagree.
Yeah, but as I said, it's a really interesting perspective, and I have to think about it a bit more.
Restriction. So, I never teach this. I always skip over the slide and just pretend that I know why this is useful for. Because if you ask me, it is utterly useless. Basically, yeah. Keep the data, don't delete it, keep it for me.
Top 10. Yeah, I'd say delete this one as well. What do you need to restrict when you have object and erase?
I think this is so that people don't start like burning the evidence. Like you have a legal case against me and I want to ask you not to delete the stuff. Maybe. But it's such a narrow use case, it shouldn't be a data subject, right?
That's what I'm thinking, that it should be go into something else in that case. Gone. 19.
Oh, yeah. This is, I think this is what we were talking about. Shall communicate any rectification or erasure to each recipient, unless this is impossible.
Yeah. I think that is sort of a given. That when you, for example, stop using a processor, then they are obliged to delete the data anyway. And then all of the controllers have an independent responsibility, joint or whatever, to delete data that they don't have a legal basis for. So I kind of feel that this is a bit redundant.
Yeah. And also the controller shall inform the data subjects about those recipients. That's already part of the information requirements. So why?
Yeah.
Maybe of those you asked for deletion, but you have to inform about recipients. Portability, meh.
So that was delete?
For
19?
me, it was that you need to inform others.
Cool. Yeah.
I would say, I don't know. Like, we're just doing this on the fly.
Yeah. Yeah, we are. Please keep that in mind, people, that we're doing this on the fly, and it's already 45 minutes, so we need to speed up.
Yes. We didn't.
Portability, I would delete.
Yep, agreed.
I would, and for the entirety of the GDPR, I would add, and let's just say that straight away, that I wouldn't just delete everything. I would create, the most important thing is the difference between the small and medium-sized businesses and the bigger ones. That pertains to so much here. And for example, the data portability should only apply to like big tech type of controllers.
Yeah, agreed. I would keep object.
Yeah, me too. 22.
Profiling. Yeah, doesn't work, I think.
Yeah, I got some feedback on that too. People saying that it doesn't work in practice. It's too difficult to comprehend. But I wouldn't delete. I thought really hard about this, but I've ended on not deleting it because it's just too it is, with everything that goes on now, what else is there to protect us, sort of thing. So I haven't enough information to say that I would delete it.
One thing that we could do, shall have the right not to be subject to a decision. So we should interpret decision narrowly, I think.
Mm-hmm.
So this should be like a special case provision, and then let other legislators deal with what they should be dealing with. Yep.
Yeah.
National exceptions. This is fine to me.
I would move it from there
to
but although it pertains to the rights, I would have it in the beginning, like the scope. But that's,
it can be moved for sure.
Then the bulk of the thing that we haven't even started on yet. Maybe we have to do 2 parts of this, Miloš, but let's give it a shot. I have some specific thoughts on this, and I'd love to hear yours.
Yeah, so this is documentation, right? Number 1, shall implement technical organizational measures and be able to demonstrate compliance, useless, redundant. You already have the principles and the accountability principle, which Miloš said keep. Where proportionate, the measures shall include implementation of appropriate data protection policies, doesn't add anything. And you have the codes of conduct shown themselves very useful in practice. Delete 24.
You delete the entire 24?
Yeah, why? What does it add?
Oh my gosh, I would keep that as one of the biggest, most important provisions, because I would, so overall, I would build out the data protection part of GDPR, because the DP actually stands for data protection. It doesn't stand for privacy. And there's too little focus on the security and protection part of the GDPR throughout the GDPR, but also in practice, as we see now with years and years of GDPR implementation. So I would rather strengthen 24 and the overall security obligations combined with the risk-based approach. And yes. I think that would be much more effective. And as you know, I would probably delete 5.2. So I would have to keep it there. And then, with the 25 as well, build it out to focus more on the data protection part.
So to me, both 24 and 25, literally, you can move parts of them up to principles, but this is nothing new. This is nothing new. This is, I'm not going to say useless, but
it's new.
But isn't risk already part of 32?
But we haven't come to 32 yet. We're at 24.
But you do have risk assessment sprinkled throughout, and for the legitimate interest, you're going to do the same. I don't know. To me, it doesn't bring much. 25, despite it being very fancy, overused term, brings nothing to the table. Like, basically, you need to adhere to data protection principles when you start building products. I mean, sure, or services. Sure, if you don't, I mean, you're going to end up with something which is illegal. So, I mean, your choice. But
so
25,
what would you do with 25?
Delete. Redundant.
We are so in disagreement here on 24 and 25.
No, but I mean, come on. What they need to do, they shall implement appropriate measures which are designed to implement data protection principles. Nothing new to the table.
I think it's really, really undervalued, 25. And as I said, I would rather build out, have a much higher focus on the data protection part of the GDPR, and then lessen the focus on the documentation and the notices and the data protection policies. Maybe that was I would delete this one from 24. The policies part, because we have so many paper pushing exercises in the GDPR now that, and I read the other day that Norwegian airports they have 400 to 700 million cyber attacks a week. It is mind-blowing. So we need to focus more on actually securing the personal data rather than transfer impact assessments and everything. And I personally think that Article 25 is something we need to think more about.
Yep, to me it brings nothing new in relation to 5, and I think security you have covered through principles and 32. But yep, join controllers.
Delete.
Delete immediately, forget it
Yeah.
existed, burn it down to the ground.
That is the one that we burn. Yeah.
Yep.
Because if you're a controller, you're a controller, right?
Yep.
27, delete.
This is where I found that sentence, jointly means together
alone.
with somebody else and not alone. The definition by the DPB.
Yeah.
Delete. But representatives, sure,
Delete.
but put it somewhere in a delegated act. Remove.
Yeah, I would definitely delete that because it doesn't work well in my opinion. Processor.
We had an episode. I think that the division of roles controller processor is broken at its core. I do also think that it's unreasonable with the due diligence checks at the level they're put, how sufficient guarantees is implemented. I think that these contracts, the division between contractual stuff and GDPR stuff doesn't really work. I like the idea. I like the idea. I don't like the implementation.
I agree. I think it's important, but I would maybe explore the idea of actually mandating processors to be the one responsible and primary liable for sub-processors instead of the controller.
Yes. Agreed. Because they're the ones deciding the means there.
Yeah.
More or less.
They are the one who are contracting directly with them. It only makes sense that the ones liable to the data subjects are the ones who are actually contracted with the parties directly, in my view.
Under the authority of controller, processor, and nobody else who has access shall not process redundant.
Delete.
Records. You do. 30.
Oh, we should have had this 2 years ago. Then I would have highlighted it and probably drew a few hearts around it. And now I've been thinking about, are you ready, people? Delete Article 30. Because as I mentioned earlier, you have the overlap between 12, 13, 14, 15, and 30. And I see the idea, I get the point, I get the intention, but it doesn't work in practice. Like, I have been out and I have worked with over 100 companies of different sizes. And I still want to see this being managed in practice as it's too big. So if not completely delete, I would really, really scope it down significantly and only to cover what isn't covered in other provisions already.
Ooh, how the tables have turned. Because if anything, I hated records of processing evidentiary purposes. Like, I think this mostly serves if data protection authority wants to come knocking, but I think it's super useful if you're updating privacy policies. But that leads us back into your point, too much overlap, condense the bloody thing.
Condense it and combine provisions to cover the most important aspects, and which are, people want to know what we do with their personal data. Like, I want to know what you're doing with it. I want to be able to object or whatever if I'm, don't agree with your processing. But this is just too much, way too much.
It is.
But considering that we've deleted half of the GDPR, it would automatically become simpler, right?
Yeah. Now we have something that sounds, I'm not going to name any countries, but from Montenegro, let's take it like that. The controller and processor shall cooperate with your supervisory authority.
Completely redundant. Of course, that is a given.
That is a given. And to me, the sound of this is a bit undemocratic. I see the point, redundant. Security.
Yeah, as I said before, my point stands with the combination of 24, 25. Not necessarily combining all of them, but I think these are some of the really key provisions in the GDPR that is constantly undervalued because we have been dealing with transfer impact assessments and opaque privacy notices.
So I love 32 because I love its focus on risk. So in general, I do really like it. I would raise you a different point, and that And that's that there is too much focus on security in practice. When people talk GDPR, they talk security. So I would actually perhaps even shorten it. You know how many people hear GDPR and only think security, consent, deletion. So I'm not sure.
I don't think a lot of people think security. I don't have that impression.
That was my experience. That the
I have
main
the
focus was
opposite
on security.
experience.
No, I mean not data protection officers, but actually people like, let's say, IT people.
Yeah,
but
I don't have that impression.
Notification. Oh God, 72 hours.
Way too short. So I agree with the article, but I would have a bigger window, and I would absolutely 100% increase the threshold of what's the risk. Because, for example, look at the Norwegian DPA's website. They say that if I send an email to an incorrect recipient, that is a breach that is notifiable to the DPA, which is absolutely ridiculous. Again, it has to be about the context. And if I send the email to an incorrect person, I can't be sending a notification to the DPA. It is absolutely ludicrous. So increase the threshold and increase the number of days.
So in a high risk, I mean, come on, somebody clicks wrong on SharePoint internally. This is, maybe I would limit it towards third parties as well, because as a controller, you should already have, no. I'm not sure, but yeah, threshold different anyways.
Yeah, so not that I wouldn't say high risk, but there needs to be, why not use the ENISA framework for defining the levels of risk here, for example? 34.
I think, yeah, 34, I'm fine.
Yeah, me too.
DPIA, get rid.
Oh my gosh, this is the most recurring from that I've gotten feedback before this session, that somebody said, I'm a DPO and public servant, and I absolutely hate DPIAs.
I'm going to repeat this. Yeah, I nearly cried the first time. In all fairness, one of the first things I was asked for was for Microsoft Office. It's so unnecessary. Sit, think about the principles, evaluate your legitimate interest, evaluate your consent. But this, come on.
So I also had to really think about this, and I ended up with combining it with all the security stuff that I mentioned earlier. So I absolutely think that there are use cases for a DPIA, but I think the GDPR should have spelled out the need to do risk assessments, because everybody's been like, no, we don't need to risk assess everything. It's only like the IT system or whatnot. But I think that you need, on an overall level, you need to risk assess your processing activities, because otherwise, how would you know if it's high or not? And then, depending on the context, you would see, do I need to do like a more thorough risk assessments and call it a DPIA or whatever? But I would definitely scope it down, and I will also remove everything that just encourages different enforcement. Because when they make their own lists in each country and lists of what you don't need and what you need, makes no sense at all.
No. And if it's high risk, likely no legitimate interest, right? Or it would be tough to balance. And look, people should be able to say yes to high risk. So I don't know.
Oh, that's a podcast in itself.
Yes, prior consultation, useful. Please, have you ever actually consulted authorities on this?
I was about to. I had plans to in 2020, but I never got that far because it was too much work to prepare the entire case. So I didn't, and I haven't heard of many. I think I've heard of one or two. So I'm not sure I see the point. I would take it out of the GDPR and rather, all the DPAs should allow for this anyway.
Yeah, as part of tasks in any case. You take over designation of DPO.
Oh my gosh. So I know it's 10:01. Some people have left already. And this is going to be another bombshell. First of all, what do you folks think I will say? Will I say keep or delete? Shoot some comments so I can see them.
Well, now you've primed
Because
them.
it's of course I think I have this nickname now, the Grumpy DPO, and I've been an external DPO for years. I think DPOs are superheroes that are doing very ungrateful work and are constantly understaffed and under-resourced. But I actually think I end up there. I would delete.
Want to elaborate?
And
More resources?
I read a comment that I made in my Obsidian the 18th of October that delete the DPO role from the GDPR.
Interesting, because I'm for keep.
No!
No, because it raises visibility. It raises visibility, it gives you protections.
I am very surprised to hear that. I was absolutely convinced you were gonna say delete.
I changed my mind as we speak, right now. Probably just to be contrarian to you.
Yeah, probably.
Like last night, I was going to bed and I thought delete, but keep, because it raises the visibility of data protection and it gives excellent guarantees of, but change the stuff.
Really? How does it raise visibility?
Of
and
privacy?
And what about which guarantees? Like how?
So it raises visibility because you have to have a person who will, well, hopefully have to do something. So it at least raises consciousness of people. We have to do something about privacy. But I don't know if I would keep all the same tasks and everything formulated the same. But I think obligating every public institution to have somebody working with data protection is good. I'm sorry, I know this
What
is
about the
surprising.
guarantees? Explain your view on the how does it guarantee anything?
It doesn't. But it's about teaching and communication, I think.
Yeah. No, I fundamentally disagree, because that is the intention, like that is the ambition of those articles. Like that is what we wanted to achieve. That is absolutely not the reality. And I think there are a few things here. And the most important for me is actually the carpenters. Again, if people on this live aren't familiar with the carpenter, then please go back and listen to some of our episodes, because the carpenter just represents all of those that are struggling to implement this in practice, because it is so unreasonable requirements for those who have this really tiny business with very limited type of personal data and processing. And in some cases, you might be required to have a DPO and it doesn't make sense and you don't have the resources to do so. Yeah. Which just only then results in somebody being forced into the role. How about small companies that have massive processing activities, but they are 3 people and everybody's a C something, CSO, CFO, CEO, and so on. So I don't think it works in practice. So as to your point on the public entities, yes, for sure. I think there must be a role mandated, but I wouldn't call it a DPO. So I would actually take it out.
I would maybe tweak this list and expand the protections, and tweak the scope for SMEs, definitely, of the GDPR as such.
Yeah.
But this list can be revised and then it could be made work, which is a compromise between you and me.
Okay, that is actually a good case. Yeah, I'll have to admit, I'm not 100% on delete, folks, so don't worry. But that is kind of the feeling that I have now, because I don't see that. I have spoken to too many of you who are extremely frustrated, and many people have actually left. I have talked to a few of you who have actually left your job as a DPO because it's too much, not even just hassle, it's too ungrateful. You're not appreciated and all. So that is part of the reason why I'm kind of leaning towards deleting. But if, Miloš, we could compromise, I would definitely add the exception for the smaller business, or it needs to be clearer.
Yeah. And then depending on what we do with that, 38 and 39 would be affected, right?
Yeah.
So I don't have like strong opinions here.
I would just do one article.
Yeah, exactly. Codes of conduct, delete immediately.
Delete. It doesn't work when we know that the EDPB takes at least 2 years after the round in the DPA to get a code of conduct out. Just look at the timelines. It is not working at all. It is true. And another comment on that is that when it takes 2, 3, 4 years to get the code of conduct done, and then how likely is it that the processing activity stays the same? It is highly unlikely. Maybe you change the email service provider and all of a sudden you have US transfers in the mix. Then you have to redo the whole thing. So I don't see this working at all. So I would delete everything on codes of conduct.
Everything about it, yeah. I find it also undemocratic. Yes, never mind. We'll come back to that. Certification. Yeah, unnecessary.
Yeah, I think I would delete just based on the experience so far.
Yeah. But
unfortunately,
I mean, it's not just a question of practice. I can't of how much it's been done so far, but also its general usefulness. My God, this is why I said we are going to wrap up soon. Chapter 5, delete.
Yes.
Entire thing, entire bloody thing. What does it do in practice? Does this actually raise the level of protection of personal data, which is the goal of the European Union? Does this do anything in practice? No.
On the contrary, I would say that Schrems 2 led to such misuse of resources for thousands, hundreds of thousands of companies and organizations, everybody doing the same, everybody trying to assess US law on their own. It is absolutely incomprehensible. It's such a waste of resources. It is actually such a waste of taxpayer money. It is super provocative. I get so grumpy thinking of everything that's gone on after Schrems 2. And, that work is super important, what Max Schrems have done. Of course, I'm not criticizing that. I'm just criticizing the practical effect for people in practice. And expecting small controllers or any controller to do a transfer impact assessment, assessing the laws of a third country is absolutely incomprehensible. Everything should be done on a European level.
I actually don't think it should be done on the European level either. The idea is to create this bubble for personal data so it's protected as if it were in the EU. Come on, not realistic. Yeah. Delete.
Yeah, it doesn't work with how the internet works and how the global world works. It doesn't work in practice at all. And that is the reality of how the world works. Like, we're on LinkedIn now, people. It's and we have so many of the privacy purists, the GDPR extremists that are still on LinkedIn complaining about everything and transfers and whatnot. And this is just how the world works, in my view. But I do think, and again, it comes back to two things, context and risk-based. So under the risk and security new amazing provision that Rie has created, then add transfers in there as well. So risk assess your transfers too. But I do think that the Commission or, whomever want to do it on the European level should have some sort of either a white list as we have today, like the adequacy, or a red list of the countries that do not transfer to or that represent high risk. I'd rather do it that way.
I see 0 point with data localization discussions as such. If you're using processors from abroad, take that into account during your due diligence thing. If you see that it's a processor who keeps disclosing data all the time, I would not like a mention of any transfer outside of EU at all.
Okay, then we disagree on that.
Yep.
And then on the contractual stuff with transfers, not even transfer, like not international at least, but disclosing data between entities in a group, for example, corporate group. Maybe I was toying with the idea of how about a disclosing provision instead? An article that pertains to the recipients and the sharing of the data. So we combine everything into one of those.
Yeah. I don't know. I'm keeping silent because I said delete the whole chapter 5. No comment. BCRs, not useful in practice. Because it's after Schrems 2, so you have to implement the guarantees anyway, so you are not out of that.
And I think all here as well, just do something on the contractual side and stop pestering us with SECs that are absolutely meaningless. And the fact that the Commission said that, oh, by the way, when we got the new SECs in 2021, they don't pertain to this particular scenario that is the most relevant to everybody. And we are still waiting for those, and they are due next year sometime. And what does all of this end up with? Like the whole chapter 5, transfer impact assessment, SECs, it's paper pushing exercises. And I get, of course, both Miloš and I, we get the aspect of the protection and all of that. But I think it has to be dealt with on the European level in terms of good or bad countries, so to speak. And Miloš, I don't know how you would how would you manage then transfers to some of the dodgy countries?
I wouldn't, because you cannot. Yes.
Okay.
So then we have a bunch of articles on supervisory authorities, their competences and stuff. I would just combine all of that, condense, proofread.
Yeah.
I love my pettiness. But yeah, all of this can be regulated through delegated acts. So just condense, there shall be independent authorities, they shall not be instructed, and yep.
Like, seriously, people, how many of you have read any article after chapter 5? Maybe you did once, but how many have read these articles and these chapters after 2018? The only interesting, like, there are, of course, the we come to the fines, of course, and then 77 will come there as well. So, but I agree, let's combine, take everything that pertains to procedural or administrative between EU bodies or supervisory authorities, just take it out and put it in somewhere else where the rest of us don't have to bother with it.
So we are at 60, cooperation and consistency. Scope down to 2 or 3 articles. They've already done that in the DSA. They've learned from One Stop Shop, and they've learned from having an EDPB. So they've basically said, here is an advisory body which can decide nothing. And
I'd take it out. I take all of it out, everything. Like everything that pertains to these processes between regulatory bodies, I'd remove from the GDPR itself, or put into, again, I'm not a lawyer, so I don't know where to put it, but it shouldn't be in the bulk of the legal text.
I would basically condense everything and add one point on they shall cooperate in good faith, period. EDPB, I would significantly reduce their competences. One-stop shop, I would eliminate. It has become a banana measuring contest. So just remove.
Yeah. Again, on the EDPB as well, or everything that relates to this topic, get it out.
And half of this can just be part of a delegated act. I mean, the EDPB shall have a chair. No, they shall have a table.
Yeah.
I mean, come on.
This one, move to rights.
Let me see. Yes, agreed. Right to lodge a complaint.
Everything that pertains to a right, put it in chapter 3.
And I would specify, I would add to this one that they have to handle a complaint within a period of 30 days or additional 30 days,
why we get a month, so why not give them a month as well? So I think that's unreasonable, and but it's a good point to make.
Yep, you can sue them. 78, that is fine.
Yeah, and you have the within 3 months, but that doesn't. I'm not sure how often they keep those deadlines either.
I suspect
79.
Right. It goes without saying that you have a right to effective judicial remedy, and the jurisdiction part I would take under the Brussels regulation. I think this is covered under other laws. There is no need to specify it here.
That's my thought as well, that this should already be covered. Representation?
The same. We have new legislation. Sure, not everybody is a consumer. Sure, no. But if we do remove business to business, I think we could use consumer stuff here instead of GDPR. Yeah,
if we get the same effect, I would remove it.
Yeah.
But not otherwise.
Suspension of proceedings, list pendants already in Brussels 1 regulation. No need to have special GDPR.
Yeah.
Oh, delete.
Ooh.
82. Germany
Yeah,
said delete.
some said also delete in their feedback before the session. And
The
it's
country.
just, sorry?
The country of Germany said delete, this is too abstract. The court rulings have been insane, incomprehensible. You know, you experience fear. Well, if it's purely hypothetical, then you cannot get any damages. But if you did lose 1 crown, then you have to be compensated. But they cannot look into whether you did it again and again and whether you did it intentionally. It's insane. Delete.
But wasn't there a Supreme Court ruling from Germany recently that effectively weaponized this part of the GDPR?
I mean, it has become, there was a person also who skipped a line. The CGU case, there is a bunch of silly examples. We need to give people the links. So what would I do? Of course that you can sue controller or processor, but I would not try to harmonize this on the European level. I would leave it up to a national state, because local judges and local companies are going to know local law better. And for example, in Norwegian law, you would normally not be able to sue somebody for 1 Norwegian crown.
Yeah, I think it's problematic. I think it is so problematic that it should probably be solved somewhere else, because
Just leave
it's
it
too
up to
unclear.
national.
Yeah.
Like, yeah.
Fines.
Random.
I would say narrow scope down and combine. And there's no need to have different penalties or fines for the 20 and the 10 million euros. And also, I don't know if everybody knows this, but actually in the GDPR, there's no fines related to Articles 10 and 24. So that is left up to the member states to decide. And I'm not sure if that was intentional, because I looked into this a few years ago, and it seems to have been missed out. So in Norway, for example, we can fine people for 10 and 24 breaches, but it's not the case in all countries.
10 is criminal stuff, yeah. But given that I would move the first and delete the latter, I'm not going to go into that. But I agree with you, no need for 2%, 4%. Differentiation.
Yeah, just have one. And also, just like a general point, anything that allows the member states to define it differently, I would delete most of it, unless there's like really solid reasons why a member state should have their own rules.
Yeah, which is exactly the case with penalties, that they can make additional penalties for breaches of the GDPR.
Yeah.
And then we have this stuff, which is Article 85, freedom of expression and information. Keep, but start actually using, maybe in practice.
Yeah.
Okay, very important. I would even make a principle out of it.
Ooh, that's interesting. Yeah, that's a good suggestion. Oh my gosh, wouldn't everybody love our GDPR? Now, I know I've seen some of the grumpy comments, so I know not everybody agrees with us. But okay, let's move on. Anything in this section that is very particular to member states, I don't really see why it's necessary. The national identification number, for example. Again, I would delete that, because that would come back to the context and the risk-based approach.
Exactly. The same with employment, the same with, I think statistical, scientific, or historical research under 89 would be very, very useful, but I would either make a special regulation there or actually explain what those terms are.
Ooh, I like that, a separate regulation. Or, we are the first to say, oh no, not another regulation.
Yeah.
But for like special cases, I absolutely see it. This is different than all the general application regulation, so to speak, that are being churned out of Brussels. But I do see there's absolutely a need for this. I dug really into this also a few years ago. But if we make it like a special regulation, then we could take out all the references throughout the GDPR to this as well. So keep, yeah.
Obligation of secrecy, lawyers, priests, member state law, fine. I'm fine with that.
Yeah.
Churches and religious, I have no idea why we would have churches separately.
Yeah, it makes no sense.
I don't know.
I would actually, in all of these types of regulation, I would have a separate part of the Implementation Act. I don't know if this is even possible, but I would put everything that relates to transitional rules that you find riddled throughout the legal text. Like there are references everywhere to other directives and how this will work and if this worked this way and yada yada, and like 91 here as well. Why don't you just have that in a separate document that is called like transitional rules, so that people don't have to pay attention to it when they are starting to work with this in practice?
I will challenge you on that. It can and should be condensed. I think we need more. So the Parliament would, of course, need to give Commission the power and so forth and so forth. They could do it in another document, but I think when you look into overlaps, what is regulated by AI Act and what is regulated by the GDPR? But then we're back to scope, Article 1, right? Article 2. So maybe.
And you wouldn't account for anything in the future. So could it be possible to have a separate thing on the side that could regulate everything that was and is to come?
So what they do with some consumer stuff is to have an annex of how it interacts with something else and then update the annex.
Yeah, I like that. Let's do that.
Yes. And okay, e-commerce directive, fine. Commission reports, entry into force, fine. You know what? Delete entry into force. It never happened. It never entered into force. You have a time machine.
But seriously, everything that pertains again to tasks and powers or obligations related to supervisory authorities, the EDPB or the Commission, take it out of the general part, or it's not that it is part per se of the general part, so to speak, of this. Oh my gosh, I confused myself there. But I hope you get the point. Take out everything that pertains to that and keep it separate. If it has to be in the GDPR, fine, but an annex or a different regulation or transitional rules or whatever.
Yeah, it's tricky. Just because of the structure of the EU. I agree with the underlying thought, but I don't know how they would do it in practice. Certainly it can be condensed, though.
Yeah, but it's not really realistic to implement our changes anyway. So if we are to dream, Miloš, then,
Because I do have a small announcement to make. I've gone a little bit into politics recently, and I was actually thinking of running for the European Parliament, and my platform is going to be the reform of data protection legislation. So today's draft.
I will vote for you. You have my vote.
I'm joking. But how about we publish our GDPR?
Are we done? Hang on. Are we done? Have you reviewed all 99?
Have we not?
Yeah, but we need to make like a thing of it. We went through the whole GDPR in one sitting. Article 99, we are done and dusted, people. I really hope that you enjoy this as much as we did. And, please take our comments and this whole session with a grain of salt. But I hope it shines through what we actually try to demonstrate here and to show that in practice, this is highly problematic in my view, and the GDPR needs to be revamped, which is disappointing that the Commission didn't take that more, considering the review report that they released this year, which had lots of comments on what's wrong with the GDPR now. And the next point is when is the next 2028 I think is the next opportunity.
I do want to echo your point. So we do not prep for this. We do this very lightheartedly. We talk the GDPR, Grumpy GDPR banter. Any part of this we do take a risk in a way to be this open with everyone. Snippets of this can be really, really damaging to anyone's career. So
don't give them any ideas now.
No, I'm not. Fairness of processing. They would have to inform me. Come on. But the main idea in any case was to show exactly lots of this does not help the data subjects. As it is formulated, it does not. Overburdens the businesses, it does. So cut. And I think that on that note, we agree actually on most stuff. Or is there going to be GDPR 1, GDPR 2? Miloš Rie GDPR?
I think there were some really significant differences between our views. For example, so let's aim at wrapping up in about 5 minutes. But I think the security aspect was really big for me. And the 24, where you wanted to delete 24 and 25. So that is really interesting.
Yeah.
What else? Chapter 5, adequacy decisions. I want to keep in some format. Not necessarily, I wouldn't have it in its own chapter. I would just do context and risk-based. I think those are my 2 keywords for everyone today.
Yeah. I've told you my opinions. I think that security is already has risk assessment built in. I think to avoid overfocus, it's fine not to expand. 24, 25, I don't see them bringing anything realistically to the table. Think on data protection principles when you build products. Of course, well, you have to develop something with data protection principles anyway.
Yeah.
And but that is fine. And DPOs.
And DPOs, not least. And I just want to show so we intended to go through the GDPR with gdpr.fan. So if you haven't used that, please check it out. Forever ad-free. There will never be pop-up ads on this website. But another key point, and the reason I'm showing this, is the plain English. The sentence in Article 12 that I think is so undervalued. If you manage to explain data protection obligations in a way that people understand, we have to tailor it to our audience, to whom we are speaking with, then we will achieve much higher compliance. I am absolutely convinced of it. So I hope that's another takeaway as well.
Yes, we can share our privacy policies. I know when I made my website that it was like, I have 1 cookie. Why do I need to inform you of this? But GDPR fan, I do definitely recommend. It's very easy to use. Love the UI. User interface.
Yeah, it's fantastic. I love it. Absolutely love it. And of course, catch us on grumpygdpr.eu on any podcast platform. And if you want to give us a review, oh my gosh, this is the first time I will ask for reviews on Grumpy GDPR, Miloš. I know you will hate me for this, but I will, because it's cool to have some feedback.
Reviews? I didn't on LinkedIn.
No, on podcast platforms, so you can rate the show.
Please share, like, and subscribe.
And oh my gosh, we have. I am just looking at the comments. I promised that we were gonna talk about some of the comments, and do you see them as well?
Let me click.
So apart from the really obnoxious self-promotional comments that I hope I can go back and delete, there are some really good input here. I think we have shocked a few people, Miloš.
Yep, that is actually good to know. I mean, yeah, they don't refresh for me, but I think that this is it's unfortunate.
Okay, let me bring one on, because I think I can show them on screen.
No, this is being recorded.
No, it's a LinkedIn user. It's anonymized. So
Anonymized. That's an F for you.
Oh my God, you are the anarchists of the GDPR.
Yes.
And I'm not going to bring any comments up. Of course, I don't think it would be problematic, because we're on a social platform that's publicly available anyway. But I'm not, for the sake of everybody's privacy. I won't bring you up if you are named. Somebody thought you were absolutely right on something, but I'm not sure what that was.
Everything. That just means everything.
Yeah, keep grumpy. Yeah, let's go through them with a cup of coffee, and I will try to reply to most of them. And I just want to say thank you so much to everyone who supported us and joined us for this really informal, cheeky session. And, we step outside our comfort zone, not so that you don't have to, but to inspire you to do the same. So that's all for today, I think. Any last words, Miloš?
No, I just want to thank everyone and to say that Grumpy GDPR is really one of the highlights of my of career things I do, but also whenever I speak with you, my day is made like amazing. So I want to thank you, and I really, really want to thank everybody for listening and for just showing up today and following with putting up with us, basically. So thank you.
Yeah. Thanks and happy holidays. Bye.
Happy holidays. Bye.